Welcome to Law Sessions. I am Jennifer Housen. In this law session on contract, we will consider exclusion clauses, and certainly we will look at it in the context of terms which are unfair. Now, this area looks at clauses where in a contract, for example, let's say you are going on your summer holiday, for example, and you decide that you are going to do bungee jumping, and you make a contract with the bungee jumping company in the Sunshine State that you're going to. The question then is, can they say to you that there is a clause in the contract that in the event the bungee cord breaks, they will not be liable if the breaking of the bungee cord, for example, is because of their negligence? Well, that's what this here is about. The kinds of clauses which exclude liability, and we will also look as well at how these clauses need to be incorporated. Again, another classic situation is where you go to a hotel room, for example, or you go to a hotel, and when you get to the room, you see the some terms on the door. I mean, it doesn't happen as frequently now, but certainly you will see that there are cases where persons have, for example, after they have started whatever it is that the contract allows, and it is then that they realize what the particular exclusion clause is. Well, we will see what the law has to say about that. The most common type of unfair terms, and the ones that we're going to somewhat focus on, are, as I said, exclusion clauses. And this is where one party seeks to exclude their liability arising under the contract. And the other example of unfair terms, of course, are penalty clauses, which we will look at briefly at the end, where a party specifies an amount payable on breach of contract which is out of proportion to the loss that the party would suffer. Now, that's not to say that if you and I have an agreement and I say if you don't finish by day 30, then you will start incurring costs. What the point about a penalty clause is that it will be struck down by the court if it is such that when you look at it, it is extraordinarily more than what you would have lost, the other party would have lost under the contract anyway. An unfair contract term can operate oppressively sometimes, and so the law restricts the use of these terms. Now, the protection comes from the common law, and also we get some protection under the Unfair Contract Terms Act 1977, as well as the Unfair Terms in Consumer Contract Regulations 1999. So these two together do provide some protection. Now, if we look at the protection at common law, the protection at common law comes in two forms. First, the courts will consider if the term has been incorporated into the contract, and secondly, the courts will consider if the clause covers the loss in question. So what we will do is we will first consider the incorporation of the unfair term, and secondly, we will look at whether the clause in relation to the unfair term covers the loss that is being discussed. Now, if we start with looking at whether or not the unfair term has been incorporated, the general rule is that the term must be brought to the attention of the contracting party before or at the time the contract was made. If the term was not brought to their attention, it cannot be said that they accepted the term. Therefore, the term will not be part of the agreement between the parties. Now, in the case of Ollie and Marlborough in 1949, the claimant booked into a hotel, our first hotel case here. Now, in the hotel room, on the back of the door, a notice sought to exclude liability of the hotel proprietors for any lost or stolen or damage to the property. So if the property is lost, stolen, or damaged, they said we would not be liable. But the exclusion clause was, of course, on the back of the door in a notice. The claimant had her fur coat stolen. Now, the court said that the notice was ineffective to have any impact on the claimant. The contract had already been made by the time the claimant had seen the notice. It did not, they say, form part of the contract. Now, if we look at another case in Thornton and Shoe Lane parking, now we touched a bit on this type of area when we looked at offer, because this is a classic scenario where you're going into a car park, and of course, as you drive to the barrier, you get a ticket, and so on. Well, in Thornton and Shoe Lane parking in 1971, the claimant was injured in a car park, partly due to the defendant's negligence. The claimant was given a ticket on entering the car park after putting money into the machine. The ticket stated the contract of parking was subject to terms and conditions which were displayed on the inside of the car park. Now, one of the terms excluded liability for personal injury arising through negligence. The question for the court was whether the term was incorporated into the contract, meaning had the defendant brought it to the attention of the claimant before or at the time the contract was made. Now, this question depended upon where the offer and acceptance took place in relation to the machine. As I say, therefore, this is a good case for offer and acceptance. And one thing I do want to point out in respect of this case as well is that when you look at Thornton and Shoe Lane Park, it is a 71 case, which means that it really was before OCTA, which now says in any event that you cannot exclude liability for your own negligence. You could exclude liability for the claimant's negligence, but you can't exclude it for your own. And as such, if we're looking post 1977, certainly this point would be moot. But given the circumstances, the court said that the machine itself constituted the offer. The acceptance was by putting the money into the machine. They said the ticket was dispensed after the acceptance took place, and therefore the clause was not incorporated into the contract. Now, what happens when there is a written contract? Well, where you have a written contract which is signed, then a party is bound by all the terms in the contract, irrespective of whether they were aware of the terms it contained. The classic case, of course, is Lestrange and Grocob in 1943. It's a Court of Appeal case, and the claimant there purchased a cigarette vending machine to use in her cafe. Now, she signed an order form which stated in small print, any express or implied condition, statement of warranty, statute or otherwise, is expressly excluded. Now, the vending machine did not work, and the claimant sought to reject it under the then Sale of Goods Act for not being of merchantable quality, which is something similar to satisfactory quality. And certainly when you do the area of sale of goods and looking at terms, I would urge you to at least look at the historical point from which the Sale of Goods Act 1979 came. That being the case, though, the claimant here sought to reject it under the Sale of Goods Act for not being of merchantable quality. Now, the court said that in signing the order form, she was bound by all the terms which were in the form, irrespective of whether she had read the form or not. Consequently, her claim was unsuccessful. Now, there is a however in this, because if there has been a misrepresentation of the terms, the clause is not effective. And the case, of course, is Curtis and Chemical Cleaning. And there the claimant took her wedding dress to the cleaners. She was asked to sign a form. She asked the assistant what she was signing, and the assistant told her that it excluded liability for any damage to the beads. The form, in fact, contained a clause excluding all liability for any damage howsoever caused. Now, the dress was returned badly stained. The court said that the assistant had misrepresented the effect of the clause and therefore could not rely on the clause in the form even though the claimant had signed it. Now, it's a 1951 case, and my view of it is that you have to look at it in context, because the fact of the matter is that if you've signed something in writing, and certainly when we look at some types of clauses and the way contract deals with them, is to say that if you've signed something, for example, and whether you've not read it, then it's irrelevant, because we've just seen that in Lestrange and Grocob. So why should it make any difference if somebody has told you what is in the form that you are signing. But that is the way the court held. And as I say, I would certainly take it with a pinch of salt because, frankly, the terms were there for her to read, and arguably she should have made sure that she read them. But that's what the court said. Now, what about reasonable notice of the unfair terms? Well, a party seeking to rely on an unfair term must demonstrate that they gave reasonable notice, meaning that they took reasonable steps to bring the terms to the attention of a reasonable person. A good case is Thomson, London, Midland and Scotland Railway in 1930. Now, in that case, the claimant was injured while stepping off a train. The railway company had displayed prominent notices on the platform excluding liability for personal injury and damage to property due to negligence. The tickets also said that they were subject to terms and conditions displayed on the platform. The claimant was illiterate and could not read the signs. She argued that the exclusion clause was incorporated into the contract as the railway company had not brought the clause to her attention at the time the contract was made. Sorry, I think I said it was. No, it wasn't incorporated because they hadn't brought it to her attention at the time the contract was made. The court said that the clause was incorporated. There is only a requirement to take reasonable steps to bring the clause to the attention of a reasonable person. There was no duty to ensure that every traveler was aware of the clause. The claimant was therefore unsuccessful in her claim for damages. Now, if a clause is particularly onerous, then the more steps are required to bring it to the notice of a reasonable person. But I want to pause for a minute and say to you that this kind of situation you need to consider when you're looking, for example, at where the examiner gives you somebody ordering on the internet and there's an exclusion clause, for example, and the examiner then says that there is a checkbox and the person signs up to it. You need to consider that fact pattern by analogy, because does it matter that you have to go to another page on that company's site if it is not displayed on, say, the front page? Well, as far as the courts are concerned, the courts say that as long as it is brought to your notice, that is sufficient. Now, in the case of Interphoto Picture Library and Stiletto in 1989, the claimant ran a photo library. The defendant was in advertising. The claimants advanced some transparencies to the defendant for his perusal, and he was to get back to them as to which photos he would like to use. Now, the package of the photos contained a document saying that if any transparencies were kept longer than 14 days, a £5 plus tax holding fee would be charged per photo per day. The defendant had not read the document and then forgot about the transparencies and failed to return them for 6 weeks. Now, the claimant brought an action claiming a holding fee of £23,783. £5 does add up, as specified in the contract. Now, the term was not incorporated into the contract, is what the court said. It says where a term is particularly onerous. Now, if we're looking at £5 each and we get to £23,000, the court says if it is particularly onerous, the person seeking to rely on the term must take greater measures to bring it to the attention of the other party. Now, you may not in instances need to bring anything to anybody's attention, but it may still be incorporated. For instance, if you're looking at where the parties have had previous dealings. So you can have incorporation through previous dealings. If the parties have dealt with each other before, then the term may be incorporated through these dealings, even where the term was not brought to the attention of the other party. Case in point is a case called Sperling and Bradshaw in 1956, and the defendant used the services of a warehouse to store goods on a regular basis. Now, each time he delivered goods to the warehouse, he was asked to sign an invoice which contained an exclusion clause. Now, this invoice came after the contract had been agreed. Now, on one occasion, he stored some barrels of orange juice and again signed the invoice. When he went to pick them up, however, some of the barrels were empty and one contained dirty water. Consequently, he refused to pay for the storage. The owners of the claimant warehouse brought an action for the agreed price of the storage, and they sought to rely on the exclusion clause to demonstrate that they were not liable for the damage to the goods. The defendant, though, argued the clause had not been incorporated into the contract as he had signed the document after the contract was made. The court said that the clause was incorporated through previous dealings. The defendant would have been aware of the term from the previous contracts, and therefore it did form part of the contract. The claimant was entitled to payment, and the defendant had no right to claim compensation for the damage to the orange juice. The previous dealings must have been consistent, though, if you're seeking to claim under this. The parties must always, and that is important, because an examiner may say to you something happened once, it didn't happen the second time, it happened again. The parties must always have contracted on the same terms. If they have not contracted on the same terms, then certainly it may very well not be incorporated. We are going to take a short break. We will carry on on the return of the next segment, and we will certainly see again how this whole idea of incorporation works in law.